Compensation, which you may hear your lawyer refer to as damages, is money paid to you in an attempt to make up for your pain and suffering, and for the financial and other losses that you may have suffered as a result of your injury. The assessment of compensation is based upon the principle that you should be put back to the position you would have been in if you had not been injured, or as closely as possible. It is, however, important to remember that your lawyer will assess the value of the injury and loss that you have suffered as a result of negligence, and not the injury and loss that you would have suffered in any event because of your condition. The amount of compensation you will receive depends upon the facts of your case. Previous cases can be used as a guideline to assess what you'd likely to receive for general damages, but the true value of your claim will be determined on the facts of your case. The amount of compensation paid depends on the seriousness of your injury and your financial losses. Calculating how much your claim is likely to be worth is known as assessing quantum. Quantum is generally awarded under three main headings: general damages, special damages, and any future losses. General damages are awarded to compensate you for the pain and suffering and loss of amenity, which simply refers to your inability to do things after your injury that you could do before. For example, sports or recreational activities. The term is also used to cover those awards that are difficult to calculate precisely, such as loss of earning capacity or handicap on the open labour market, or loss of enjoyment such as a holiday. The starting point for lawyers in the assessment of general damages are the Judicial Studies Board guidelines, which are guidelines created by lawyers and the judiciary, which set out different injuries and brackets for the sorts of awards being made for that type of injury. The guidelines are helpful for assessing what level of compensation you might receive, but we also take into consideration previously decided cases involving similar injuries where the court has awarded damages. Any assessment will also be guided by those reports prepared by medical experts, which describe the injuries you have suffered, how they have affected you, and how they are likely to affect you in the future. Special damages are awarded to compensate you for any financial losses which you may have incurred as a direct result of the injury or negligence, and are usually items that have an exact monetary value, such as loss of earnings, the cost of medical treatment, or the value of care and support provided by your family. Where your losses will be ongoing after the date of settlement of your claim, you will be awarded money to represent your future losses. For example, if you cannot return to work, or you will require ongoing care, support or therapy, it is necessary to predict and calculate what those losses will amount to cover your lifetime. But future losses are more difficult to assess because these are events that have not yet happened, and so there is greater uncertainty. They are determined on the balance of probabilities. When assessing future losses, the objective is to calculate the amount of money which can be invested today to produce an income which will last for precisely the period of your future loss. The multiplicand is a term used to represent the amount of your annual loss. This is then multiplied by the multiplier, which is a number taken from special tables to represent the period of your future loss. There is also an issue of what is known as accelerated receipt. If you are awarded a lump sum for a loss that may occur in the future, you could earn interest on this, meaning you have to be overcompensated. To combat this, the court assumes that any compensation will be invested at a certain rate, and this is known as the discount rate. Although you will be properly compensated for those financial losses which are reasonable and which result from your accident, you are also under a legal duty to mitigate your loss. This means that you should do everything you can to keep your losses to a minimum. For example, if your injury improves to the point when you can return to work, but you choose not to do so, you will not be compensated for any loss of earnings beyond the time when you could have gone back to work.